How's your mom?
She's fine, Your Honor. Thank you.
Give her my regards, please.
I will. Thank you.
Thank you.
Report well, now President, Honorable Chief Justice Borja today.
Good morning, councils. You may be seated. Will the clerk please call the case?
This is Supreme Court case number WHC25-003, Julio Kanga Certeza petitioner, the Alan Borja Warden, Department of Corrections, and Randall Cunliffe, respondent. Appearing for petitioner is attorney Zachary C. Tamanglo. Appearing for respondents is attorney William Stamps. Panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Tamanglo reserves 5 minutes.
You may proceed, Mr. Tamanglo.
May it please the court. Thank you, Chief Justice Torres. Good morning, Justice Merriman, Justice Carbolito. The court is well aware of the procedural history of this case. We've been brought before the court today to argue the claims which Mr. Trapp did not raise when the appeal was ultimately dismissed in favor of a writ of habeas corpus at the Superior Court level. The issues that were raised by trial counsel to Mr. Trapp were numerous, but first we'll address the police statement admission. The objection to the statement being elicited by prosecution at the time was hearsay. If the court were to review the transcripts from that interaction between parties and the court, we put forth to the court that the evidence was inadmissible hearsay, that the trial court misapprehended Rule 807. And in the admission of the hearsay, the statements surrounding them by the prosecutor were improper as well.
How is it that I assume you're referring to the residual hearsay exception, which the trial court admitted the police report that contained the 4-page victim's statement. Why was that exception not a correct exception to apply in the circumstances of the objection?
Well, Your Honor, the statement was made out of court first, and the prosecution was relying on it. We put forth to improperly bolster the testimony that was presented during direct examination. And it's that improper bolstering that makes it improper. We're saying to the court that first it's hearsay. The residual exception, I believe, does not apply in this matter because the person was present and ready for cross-examination. There's been no impeachment at this stage of the trial.
Was it trustworthy and was it probative of what testimony was provided?
It very well might have been probative, Your Honor, but it was overly prejudicial in its impact, that the danger of the jury coming to a conclusion on an improper basis was great, and in fact probably impacted their decision-making ultimately when going over in deliberations. If we look at the statements surrounding it and we extract further, there was also evidence pertaining to drugs that was objected to. And these statements about the drugs were not in the transcripts directed at Mr. Certeza, rather his associations. So the evidence put forth in the trial was such that Mr. Certeza frequented a home by one Janelle, the resident of the home. The reputation of Janelle was put forth in testimony such that Janelle is associated with drugs, perhaps a drug dealer. Testimony was elicited that Janelle often asked the named victim's boyfriend to deal drugs for her, and that Mr. Certeza is always at Janelle's house. There was improper prejudicial testimony that people who do drugs, they kill people. And we do cite to the transcripts for that particular statement. So this bell could not be unrung when we're talking about a person who, or Mr. Certeza, who was frequenting a house supposedly owned and resided in by a drug dealer, that Mr. Certeza is consistently there, that he is now a drug perhaps user, perhaps a drug associate, and that by painting over him with this brush, it was overly prejudicial to Mr. Certeza, and there was
But
many.
how is that related to any of the issues that Mr. Trapp may have failed to raise? I mean, was that one of the issues that trial counsel had provided a recommendation of what issues could be raised on appeal?
I think that was contained in the letter from Mr. Cunliffe to Mr. Trapp, that there was some improper drug evidence admitted. And this was one of the issues that is raised in this appeal. If this appeal went forward, certainly this issue lends itself to an appeal. That by painting him with this drug user or drug associate brush, it then makes it more likely than not that he is guilty of this other offense, which is improper character evidence, perhaps. It was legally irrelevant in that sense, where it's overly prejudicial more than it is probative. And then, turning now to the jury selection. In the letter, Mr.
Before you go to that, I want to go back to what I think is probably one of the most important issues here, and that is the residual exception to the hearsay rule under 807. And why was the admission of that evidence not harmless?
That it's improperly bolstering the testimony, the sworn testimony made in court. There's been no impeachment at this stage. There's been no attack on the credibility of the witness yet. And so by allowing this bolstering evidence to come in before there's any type of impeachment made, this was improper.
Was the fact that statement was given to the jury in writing a fact?
I believe so, Your Honor. We do cite that the admission of police records is explicitly not allowed under the rules of evidence, barring some other certain circumstances. But the general rule is that police reports are inadmissible evidence. There could be exceptions, but none were triggered here in this case.
Was the statement just cumulative of her testimony?
I think it was repetitive, yes, Your Honor.
So that's one of the factors to
Yes, Your Honor.
consider.
Yes, Your Honor. But if we look at the other factors, we're talking about the overall strength of the case. As we put forth, there was no other evidence other than the oral testimony provided by the named victim. There was no scientific evidence put forth, no DNA, no blood, no fingerprints, no corroborating witnesses, despite there being several houses in the area. No healing hearts, sex assault kits. And really it comes to what ultimately, the inculpating evidence was the testimony of the named victim. And so that is one of the factors, Your Honor. But the other factors we look at, strength of the case being one of them.
So Mr. Trapp, who's a very experienced defense counsel, while he filed a notice of appeal, decided to dismiss the appeal and roll the dice in the Superior Court in reference to ineffective assistance of trial counsel. And so at the trial, I mean, you're asking us now to you filed a claim for a writ of habeas. And one of the issues was that whether or not Mr. Certeza voluntarily understood in terms of the waiver of not to testify. And so is there any evidence that rebuts that he did not understand his right to testify and waive that opportunity?
The court is asking, is there any evidence to dispute Mr. Certeza's assertion? Your Honor, in the record, there is the waiver that is signed by him. And he has put forth in his pleading that he did not understand the impact of that waiver. But as far as what I can think of for what could refute it, perhaps Mr. Trapp's notes, letters from Mr. Trapp to Mr. Certeza, any statements made on the record, I don't see any. Well, this is not evidence and in the record before the court, but investigation was made into, do these records exist? I have not encountered any. If some that the government is aware of, I have not seen it. But ultimately, Mr. Certeza is putting forth that he did not understand the impact of this waiver. And I have not encountered anything which would refute that.
So what would be the relief that you're requesting from this court today in reference to the allegations of the shortcomings of appellate counsel?
To answer the question of what we're asking for today is we are asking the court to search and see the merits that these particular issues do lend themselves to appeal. And they did have a reasonable chance of success up on appeal had it gone forward in the normal course of action. When we were previously given the order to show cause in this matter, the focus was on the evidentiary hearing. Do we proceed to an evidentiary hearing? We did put forth that, yes, one is appropriate because we wanted to raise these issues and what his knowledge was. And if the government had any evidence to refute that, we would welcome that. But as far as I know,
thought your request for an evidentiary hearing was to address the issue of whether there was a waiver of the appeal right and not the and whether that was made knowingly, intelligently, and voluntarily, not the question of whether the record was incomplete to determine whether counsel was ineffective. I mean, do you think the record is sufficient for us to determine that at least examining the issues for which appellate counsel was alleged to be ineffective is complete enough for us to make a decision on evaluating the merits of the appeal?
The court certainly can view the merits of this appeal where they put forth in the normal course. Nonetheless, I'm just restating the posture that the evidentiary hearing was presented and desired.
I don't understand how is it that we can entertain the issues on direct appeal? I mean, there's no direct appeal right now here.
Perhaps I'm misstating it with precision, but the court has these issues presented and in fact instructed us to brief of the issues raised in the letter from Mr. Cunliffe to Mr. Trapp, and we did so. And also there was also the additional issue of cumulative error that could have been brought forth on appeal. I hope that answers the court's
So
question.
your position is that there is no evidence as far as you're concerned to rebut Mr. Certeza's claim that he didn't fully understand and knowingly, intelligently understand the waiver of his rights in reference to his right to testify. And so with that, you're saying that the record is sufficient for us to make a determination of ineffective assistance of counsel? You don't feel that there is a need for any evidentiary type hearing to further flesh that issue out?
The court can look at the arguments raised on this pleading that we've put our traverse. Certainly can look at that. What in reference to the evidentiary hearing, if the court wanted to flesh that out, yes, we're prepared to proceed.
I
in that
understand
manner.
you're prepared, but you're saying that because based on your review of the record, there is just no evidence to rebut that Mr. Certeza did not knowingly and intelligently waive his rights, that that's a uncontested that's an uncontested fact, and that based on that, that there can be a proper determination of the ineffective assistance of counsel claim.
Yes, Your Honor. Turning now to the jury selection issue. The transcript order from Mr. Trapp omitted the jury selection.
Okay, I just want to go back. It's not this right to testify, is that he didn't understand knowingly, intelligently the advice to dismiss the direct appeal is what I meant.
Yes, Your Honor. Thank you. The jury selection transcripts could have shed some light on what Mr. Cunliffe was trying to raise with Mr. Trapp. But Mr. Trapp, when given that as an option for appeal, specifically omitted it from his order for transcripts. And that in itself lends itself to the conclusion that there was some ineffective assistance of appellate counsel. We don't, at least as far as the documents we have from the trial court level, we don't know who the alternates were. We don't know the manner of their selection, which led to the apparent confusion on the part of trial counsel. And having that specifically omitted ultimately, I believe, hurt Mr. Certeza's
Should
chances.
Mr. Trapp have simultaneously pursued the direct appeal, preserved those issues that Mr. Cunliffe had pointed out, and at the same time filed a petition for habeas in the Superior Court in reference to his ineffective assistance of trial counsel claim?
As a matter of procedure, Your Honor, I think that if he were to pursue the appeal here in the Supreme Court, if there was a contemporaneous writ of habeas corpus at the Superior Court level, that the Superior Court would stay all proceedings pending this matter. Nonetheless, it would have been filed. Ultimately, what would have transpired on appeal, we don't know. But then the Superior Court level could have reinitiated proceedings based on any mandates this court handed down.
And could Mr. Trapp have included in his direct appeal the ineffective assistance of trial counsel and have that looked at on direct appeal?
Yes, Your Honor. The court has entertained such appeal issues in the past. There's also been instances where writ of habeas corpus was filed downstairs as detailed by Your Honor previously. But ultimately, he could have raised the same issue. Even if the court were not satisfied that these other three issues raised could have been led to a reversal, we put forth to the court that there is a cumulative error issue that could be brought forth to the court, that this had a reasonable bearing on any appeal, that all of these harmless errors taken together could have ultimately prejudiced Mr. Certeza, and that taken all together, cumulative error did occur. And that issue was not raised on appeal by Mr. Trapp.
So your argument would be that even if all three of these claims or issues were harmless, that it would cumulatively would still lead to error?
Yes, Your Honor, that is a viable appeal issue had this gone forth in the normal course.
So I want to go back again and assume that you have made a prima facie case in terms of the errors. And I want to go back in terms of what specific relief you're requesting of this court. Are you asking this court to reinstate the appeal? Are you asking this court that your client be entitled to a new trial? What type of relief are you requesting from this court today?
Ultimately, Your Honor, we are asking to vacate the judgment of the trial downstairs in the Superior Court. We would ask for a new trial. How we arrive at that destination, I believe, might be a little longer than that. The mechanics of the procedural course of action, I think, would lead to perhaps a new judgment to be ordered at the Superior Court level and an appeal taken from that. That might be an appropriate next step in this matter. And then ultimately, if the court, if the court does not rule outright on the merits of these issues that were raised in our traverse, then the court may do so at that later stage. Not to reinstate, but to redo. Because I think the first step would be ordering those transcripts for the jury selection.
Wouldn't that entitle the people to file a return in reference to responding to what are the various claims that have been made in your traverse?
At this stage, Your Honor, I don't believe that the government would need to at this point. If the court needed further briefing, I'm sure the court would order it. But if this were to proceed in the manner that I have detailed previously, I think that that would be then the appropriate time to respond to these issues. If there are no more questions, I have reserved time.
You have
you,
8 minutes remaining.
Thank you, Your Honor.
Thank you. For the people?
Mr. Chief Justice, may it please the court, your honors. I think if we look at what's been presented to the court, I like to, or what I would like to refer to as the throw enough appeals and habeas petitions at the wall and see if something will stick under the cumulative error label. We really don't have much of a case here, but we do
So
have.
Mr. Timinglow takes the position that there is no evidence to counter that Mr. Certeza did not knowingly and intelligently understand the advice to dismiss the appeal. And that amounts to ineffective assistance of counsel in reference to giving up the right to file a direct appeal, raise the issues that Mr. Cunliffe had set out in his letter to Attorney Trapp, and that he advised his client to dismiss the appeal, file this writ in the Superior Court. And so is there any evidence that you can point to that will counter that Mr. Certeza did in fact knowingly and intelligently waive his right to file this direct appeal?
Well, I think the entire record speaks to that, Your Honor. We have,
Which part?
as was pointed out earlier, we had different proceedings at this time during the not one, but two separate habeas proceedings that occurred. The defendant never raised that issue once.
So just the fact that he remained silent is indicative of the fact that he understood that he knowingly and intelligently waived his right to file an appeal from his conviction and sentencing in the court below.
I think that's significant, Your Honor, given that the defendant, he filed that second habeas petition on his own. Is my understanding, correct me if I'm wrong. So this isn't something where he's just relying on counsel. If he wanted to bring that up earlier, he could have. I find it significant, perhaps the court will too, that defendant didn't bother to file his most recent habeas action
doesn't
until
the
after
fact-
Mr. Trapp had deceased and was not able to defend himself. I'm sorry, Your Honor.
Yeah, no, but doesn't the fact that he's challenging the dismissal of the appeal suggest that he didn't agree that it should be dismissed?
Oh, well, I think that goes without saying, Your Honor, he does, but the timing in which he does that, and timing is very crucial evidence, the timing of him bringing it up years later after the habeas petition that his attorney, again, we don't, again, unfortunately, because his attorney passed away, Mr. Trapp, we can't have that evidentiary hearing that the court was asking about whether we needed. Clearly, I don't think there's any purpose to an evidentiary hearing where the only reasonable witness is not available to testify, would be very availing, hence why it does not appear, it wouldn't appear to me to be necessary. But this all should have been raised earlier. If he didn't agree with that his appeal should be dismissed, if he disagreed with his attorney's wise counsel, as you mentioned, Justice Carbolito, Mr. Trapp was a very experienced appellate counsel. In fact, he successfully helped this court develop some of its initial habeas petitions or case law. I find it very telling, again, that happened. He didn't complain about it while his attorney was undergoing the habeas proceedings in order to take up ineffective assistance of trial counsel.
Why couldn't he have brought the ineffective assistance of trial counsel up on appeal, or filed a separate habeas petition addressing that issue? Why was it important to dismiss the appeal, to pursue that avenue of relief?
That, Your Honor, I don't know. I can't guess why he did that. I mean, we can speculate, but again, I think that's the problem that we face, is we're faced with
Yeah,
speculating
but what
long
would be,
after
I
the
mean,
fact.
even putting aside, why would any counsel, putting aside Mr. Trapp's perceptions, I mean, give me a rationale for why counsel would decide, well, I'll dismiss a pending appeal and just go forward on the bringing in an ineffective assistance of trial counsel for not advising the client on his right to testify at trial.
I think there are a couple of different factors there that might come into play, Your Honor. Now, I'm hitting here from scratch, from looking at the record. This wasn't an issue that was put to us, but the opinions of this court had suggested to counsel previously that if they were going to bring an ineffective assistance of trial claim, that the appropriate place to do that was through a habeas petition in the Superior Court. Why? So that they could develop the record, that it wasn't really a good appellate issue to begin with, unless it was glaringly obvious. So I think that probably had a huge role to play in that decision.
So if the argument was that none of the appellate issues had merit, let's then focus on the three issues that were identified or potentially identified by trial counsel.
But Mr. Chief Justice, before you,
Yeah.
you proceed with that, again, going back to my question, why couldn't Mr. Trapp have pursued both remedies? Filed a direct appeal, maybe make a motion to stay that while he files the habeas petition in the trial court, have that issue resolved and continue to preserve the right to appeal the other and argue the other errors, most glaringly as pointed out by Mr. Timinglow, the evidentiary issues. Why was not that an option? What possible strategy would exist, as the Chief Justice had asked, where counsel would dismiss the direct appeal with at least 5 issues identified by trial counsel to roll the dice on the ineffective assistance of trial counsel that could have been raised on direct?
Keeping in context that, yes, it could have been raised, but this court has already directed appellate counsel that the better place to raise that issue is with a habeas petition and not on a direct appeal.
Have we ever said that then you could dismiss your direct appeal and pursue the habeas first if your time period would have expired and filing a direct appeal that you may have other issues to argue?
Not that I'm aware of, Your Honor. In fact, I believe it was mentioned that the normal procedure would be for the Superior Court to stay the habeas petition, but I don't see anything in the rules necessarily that would preclude the reverse. No, I don't know. I don't see any reason why that counsel couldn't have filed a motion with this court and asked the appeal to be stayed pending developing the record. To me, that seems like a step that could be made if it hadn't been
Doesn't
done
that
before.
statement suggest that maybe we have an ineffective assistance of appellate counsel issue here? Not issue, but conclusion?
Under Strickland, Your Honor, I don't think that goes to ineffective assistance of counsel at all. Strickland's standard is not whether or not counsel made a mistake. It's not whether or not counsel made the optimal choice. There are lots of different reasons why these things could have been done. One of which, for example, I was going to suggest, I find it also very interesting that there were these 3 different issues that were raised in the letter from trial counsel to the appellate counsel. However, he didn't pursue those. Why? The easiest answer, the simple answer, because we're bound under case law and precedent to assume competency, and that there was a good reason for why this was done. That appellate counsel and trial counsel we give them wide latitude in directing the strategy of the cases, is that he didn't find merit in those.
Yeah, but as Mr. Timinglow points out, that now seems to be fatal in reference to the resolving some of the very important erroneous issues that may have transpired. And one of them being the evidentiary issue that Mr. Timinglow points out, that this came down to a credibility issue between the victim and the sister, and the admission of that victim 4-page testimony, which bolstered her credibility, seemed to have been the turning point in reference to what may have determined the outcome for the jury, or at least let the jury to believe what the victim was testifying to.
Well, I would respectfully, Your Honor, I'd suggest that's exactly the type of thing that we should probably avoid. We're trying to speculate again about what might have influenced the jury. Um, eh, and on these grounds, these aren't. So, and some of the things that we're looking at, the
Well, the
alleged,
standard is, was the error harmless or was it prejudicial? Did the error affect the verdict? Of course, you're going to have to review that.
yeah, yes, Your Honor. And when we're reviewing those, if we look at them, we're looking at whether or not a statement, a victim statement, which was that a hearsay statement? We have, you know, large, we have numerous rules and exceptions to hearsay. The only clear rule to hearsay, as they say, is that there's an exception to it. If we look at the statement itself, it was not prejudicial. There was no impact. It was at worst repetitive of the actual testimony.
Well, that's the problem. And then it wasn't probative. As the Chief Justice suggests, that it was cumulative. And
You know-
so how is it that it could come under the exception to the hearsay rule that was used to admit this evidence?
Again, I believe what we would want to look for, though, is clear prejudice there. That sounds more like a harmless error to admit cumulative evidence. So we have three witnesses that say something, and we're only allowed two of them to testify because they're all going to say the same thing. Well, someone's going to object to that. The person that objects, one side's going to object because they want all three.
But
The other
that's
one's
not
going to
what it's
object because
being
they've got
used
two.
for, counsel. What it was being used for is to bolster the credibility of the witness.
And again, it was a contemporaneous or near contemporaneous statement that's made and later used. So I think some of the timing issues here, if the court feels that those are important issues that point towards a prejudicial error, then that's the court's discretion. But where the information and evidence is brought up, I can see an argument where if I'm defense counsel, I wouldn't have argued that. If they didn't argue that, for example, let me backtrack. If they hadn't have, if the prosecution hadn't presented the case the way they did, that as defense counsel, I would have been objecting that they didn't lay a sufficient foundation, that they didn't do this, they didn't do that. There's on these issues of timing and what was done when. Was the credibility attacked beforehand? No. So was there a need to refresh recollection or any of these other established, understood exceptions? No. However, to me, it sounds like an experienced trial counsel would address that ahead of time by trying to present a strong body of evidence and testimony on that before that happens. Then you can prevent the attack on credibility to begin with.
But
I'm
when
not
the
sure if that answers
declarant,
Your Honor's
when
question.
the declarant here, the victim, was available to testify at trial, why would the residual exception be used to admit the out-of-court statement as a substitute for her testimony? And even, I mean, clearly the trial court's decision didn't comply with 807. I mean, 807 has a advance notice requirement. The court then also even conduct an analysis of its trustworthiness, of its materiality, of its probative value, or whether the interests of justice required. The court didn't do any of the things that 807 seems to require when it said it fit within 807. And I know you had argued that there was not an abuse of discretion for the trial judge to admit it, and it wasn't. But I don't see how the trial court did any of the analysis that the rule it cited for admitting the evidence was satisfied.
And that may be the case, Your Honor. That very well may be the case. The trial judge misstated the rule.
So if it was the case that the trial judge erred, then doesn't it come down to whether or not the admissibility of that evidence was harmless or not, right?
I believe so. I think that's correctly right, Chief Justice. And here, if
So,
we- if
so
we look
let's,
at-
let's
Yes, Your Honor.
argue why I'd like to hear from you why the error was harmless.
Well, Your Honor, I think as we, in brief, as we pointed towards the case of People versus Roten, that where a police officer's testimony was questioned as being improper bolstering, then the error was found to be harmless in large part because the statement was being introduced as hearsay, despite the testimony, despite the fact in that case that the testimony improperly bolstered the victim's credibility, it was deemed harmless because it was essentially identical. And here, that brings us back to the earlier issues that here
That's
the
one
testimony was
factor,
in
right?
fact repetitive.
That's one factor, the cumulative, was it cumulative of other properly admitted evidence? But, there are also three other factors that are addressed: the strength of the prosecution's case, the prosecution's conduct with regard to the improperly admitted evidence, and the importance of the wrongly admitted evidence. Because in almost every case, you're going to satisfy the issue of cumulative of other evidence, it would seem. I mean, that can't be the sole factor that makes a determination of whether it's harmless error. I mean, we've identified these four non-exhaustive factors to consider. And they make the argument that three of the four factors weigh in favor of finding the error prejudicial because the case wasn't as strong. There was no scientific evidence. There was no corroborating evidence from other witnesses. It was only the testimony of the victim. And the prosecution also relied upon it in closing argument. And then Justice Merriman asked about the question of the statement going to the jury and being admitted into evidence as well. I mean, not just being read by the victim, but actually being admitted as an exhibit, which seems as well contrary to how the police reports would be not necessarily submitted to the jury.
If
So-
that's,
Yeah, so I'd
Yes,
like
Your
to
Honor.
hear your points on those other things, because I think really this is a very important part of determining whether the error that might have been committed by the trial court in admitting this evidence sways the day.
as to the strength of the evidence, Your Honor, I think it would be, it wouldn't be advisable for us to, counsel's done a great job in bringing up a laundry list of things that could make for a stronger case. But at the end of the day, a strong case is someone telling the truth and a jury of their peers making that decision, whether or not the truth, who told the truth. This may have been just a simple he said, she said case. That doesn't make the case any less strong. The evidence was presented to the jury. The jury made its determination. And the fact that there weren't rape kits or rape kits, whether they were available, whether any of these other things, that doesn't make a case strong or not. I'd respectfully submit. Also, as to any prejudice, instead of this being a harmless error, trial counsel had the opportunity to cross-examine the witness. They had the opportunity to bring all of this up if there was any type of prejudice whatsoever. And that's something that the defendant hasn't pointed to and can't. Where's the actual prejudice?
But didn't Attorney Cunliffe strenuously object to the admission of the statement?
I
It's
believe
not like he ignored it.
that's right, Your Honor. Absolutely. He objected. So he placed his objection on the record. However, that isn't all he's limited to. He has the actual witness there. He can cross-examine that witness. He can put questions to the witness. Any prejudice that could have flowed from that statement, counsel could have addressed during the trial, simply through questioning the witness.
What about the cumulative effect of the inference that the sister was a drug dealer and this was a drug compound, so to speak? Everybody was involved with drugs.
Well, if it wasn't relevant to this case, if it wasn't relevant to the elements being proven, if it wasn't relevant to the victim's state of mind, what they were worried about. So we're dealing with a case where, right? If
But
we
it's
use
even
that,
a prior bad act. That's
it could be seen as a bad act potentially. However, we're also the context in which this came up is the victim was afraid that if she didn't go along with the behavior that the defendant was asking for, that she would suffer harm, her brother would suffer harm. There was the threat, that mindset, and that's certainly relevant. It's not, could it have been prejudicial? Yes. And if so, then that would have been an appropriate time for trial counsel to object on that basis to that information being brought up, have a sidebar conference, have that issue, put on the record and preserved for appeal. However, just because it could be prejudicial doesn't mean that it doesn't come in, right? We have a balancing test for that also. And here, if the judge determined, I don't recall off of the record whether or not that was objected to by trial counsel. But either way, if the judge determined that it was more probative than prejudicial, then our rules allow for that evidence to come in. And in a he said, she said case involving allegations of sexual crimes, then threat to the person or their family, that's extremely relevant. And I don't see that as being a cumulative error at all. I see that as a judge making a tough but important call so that the evidence can be presented. That answers Your Honor's questions.
Except that I thought the drug statements were in closing argument and that there was no evidence. The court never ruled on whether it should be admitted.
One moment, Your Honor, I believe I can address that. That's in the People's Brief on page 10, that the statement that is being objected to and raised as an example of ineffective assistance of counsel did happen in closing argument. However, the testimony we're talking about says that the victim testified that her boyfriend's sister, the witness alleged to be involved with drug activity, would ask about the drugs. So we're talking about the victim's testimony, that the victim testified that she knew, that's one of the reasons she knew the defendant to be a drug user and someone that was involved in dealing drugs. That's why she was afraid. The last quote from the transcript, quote, "Because people tell me that people that do drugs, they kill people." So that's why she gave in for the demands to perform sexual acts that she was not consenting to, and why the defendant was properly convicted by a jury of his peers. So it's not a cumulative, that would not appear to be a cumulative error at all. As to the issue that was also raised about the selection of the jury, again, there's no evidence that the jury selection process impacted the jury's verdict. There's no evidence that, in fact, through the letter, it's a little confusing. Trial counsel says, hey, we may have a problem with jury selection, but I wasn't in the room at the time. I'm not quite sure how the jury was selected without trial counsel being present. So that doesn't make sense. Perhaps that's one of the reasons why the experienced appellate counsel decided that the letter wasn't credible or wasn't worth pursuing. We don't know, but we do know that experienced appellate counsel made a decision that the best course forward was that the defendant had not consented, hadn't given knowing waiver to not testifying on his defense, which was the issue raised in the initial habeas. The defense counsel saw that, or the appellate counsel saw that as the defendant's best shot at reversing the conviction. And so it proceeded on that basis. As with many issues that are brought before this court, there could be 10 different issues that a party could raise on appeal, but if they bring 10 different issues, they're going to get muddled. So counsel has to make strategic and tactical decisions. How many issues am I going to raise on appeal? How am I going to raise them? What time is going to be allocated to each? And
Yeah, but
here,
I think what's troubling, at least troubling to me, is that council could have done that and still continued with the direct appeal, preserved the other issues that were pointed out to appellate counsel. That was something that could be argued in furtherance of the defendant's direct appeal, and also bring up the ineffective assistance of trial counsel on the waiver issue and the right to testify. And so I think that's what's troubling in my mind.
I absolutely understood, Your Honor, and that's why we're
you know,
here.
I've asked in terms of what possible trial strategy that a very experienced appellate trial counsel had, and no one has been able to offer any.
Respectfully, Your Honor, I'd say that the one I came up with off the cuff was
Which
you know,
is ignore
which is-
the issue, the other issues, and just focus on the ineffective assistance of trial counsel for that sole single issue.
he thought he had a winning issue and he went with the winning issue. It was simple, it was concise, and again, we don't have that benefit because he's now dead. If the defendant had decided to raise these issues before his death, perhaps, we might have an evidentiary here. We might be able to develop these issues, but he
So
didn't.
that brings up the other point, that if we feel that Mr. Tamalo has raised sufficient questions that in terms of the factual disputes, that we would remand this for an evidentiary determination. You're saying that the people has nothing to offer because Mr. Trapp is no longer alive, and therefore if Mr. Certeza was to take the stand and continue the claim that he made previously, that there's nothing that the government can do to dispute those statements?
I'm not sure I would agree with the phrasing of that, Your Honor. For example, I know off the top of my head, I'm assuming that counsel is counsel and not defendant is the individual. We have written Miranda waivers that the police now use. I mean, if the court feels it advisable, and maybe that would be a good idea. Maybe appellate counsel should have their clients sign written waivers saying that they know that, I want to bring the appeal, or I don't want to bring the appeal. I want to dismiss the appeal. I want to do, hey, we could go that route.
Well, we know that Mr. Certeza at a minimum is going to testify that he didn't knowingly and intelligently understand the waiving of a direct appeal, and that so he didn't agree to that.
And I think that brings us back to Strickland, because the issue here is not whether or not Mr. Trapp was a perfect attorney, whether or not he had the perfect strategy. It's whether or not the claims had a reasonable probability of success on appeal, and not just, throw a bunch of things against the wall and hope it sticks, cumulative error approach. I'm not sure that that's necessarily gets us across the line towards a reasonable probability of success under Strickland.
Well, Mr. Timelo points out that his client, Mr. Certeza, was prejudiced because now Mr. Certeza has given up the opportunity for the appellate court to review the other issues, and most importantly, the evidentiary issues that relating to that victim 4-page testimony that was apparently introduced into evidence, considered by the jury, not only when it was read, but during its deliberation, and that bolstered the testimony of the victim as opposed to the sister, in terms of the sister claiming that he could not have done the things he did because he was with me. And so all that now is foreclosed in terms of it being properly reviewed on a direct appeal. So that's the prejudice. That's what is Mr. Timing was pointing out.
And that's, again, that's only raises to the level of prejudice under Strickland if the court determines that there was a reasonable probability of success on appeal on those issues. As the people who pointed out, they may be errors, but at best, you're going to get to a cumulative error verdict. None of them, all three, even if they are errors, are not, they're not errors that the people feel rise to that level of being prejudicial to having tainted the entire affair of the proceeding. This court may feel otherwise. Again, if the court has in its power, if the court believe, I don't remember which one of what one of the members of the court suggested and asked the defendant whether or not they wanted to reinstate the appeal. I believe that's within the power of this court to do. If the court determined that that was an issue, the court could do that if it feels that there is more than, if there is actual prejudice on these issues. The people respectfully submit that's not necessary, and that that substantial deference is owed to Mr. Trapp and the approach that he used in carrying forth the defendant's appeals and habeas matters, and that the time for defendant to raise these issues has long since passed, and he's now conveniently raised them after the death of his counsel. Why? Well, I think the answer should be obvious to this court, because they are meritless. They don't rise to the level of substantial prejudice that would merit any further review. But he figures, hey, as long as I'm the only one talking, then I've got a better shot. I don't think that that's the type of policy that the court wants to set forth. I don't know how many other appeals that Mr. Trapp was handling during this time. Purely as a matter of public policy, that's also somewhat troubling to let someone continue litigating habeas petitions and then suddenly, oh, I forgot this one. I'm just going to bring it up now when it's most convenient. I'm not sure that that's the type of public policy that we want to encourage. The people would respectfully request that the remedies and relief sought by the petitioner be denied. Thank you.
All right, thank you. Mr. Tamilo, you have 8 minutes. Government went over by 4, so if you want 10, we'll give you 10. I don't know that you'll need it.
Well, Your Honor, it's not my intention to use all the time that I have. Nonetheless, I do want to just address one thing that was brought up during opposing counsel's argument. This court has a long history of case precedent. And in those cases where there was a finding of error, but harmless error, there were other factors that the court could point at to say it was harmless. Independent scientific testing in a drug case, or an admission of guilt at the police precinct where the error is saying that, the elicited evidence at trial is objected to and brought in. And then there is something else that can be pointed at to say, well, there is this other evidence here that says that this in fact was drugs, that this person admitted it was his drugs. So ultimately, the error is harmless. And that is missing from this case. And I would just like to speak on that. If the court has any other questions, I'm happy to answer, but I would be happy to conclude as well.
Questions? Questions? The court has no further questions. The court will take the matter under advisement. We will issue a written opinion and will now stand adjourned.